Yes, Mr. Hussain.
My lord, I was in the new rules, the current
Yes,
rules.
we have obviously lost effectively half an hour, and we will sit at 10 tomorrow.
Thank you very much, my lord. It's very kind.
You may reconsider if you are very quick today, but one way or another, I suspect we will need 10 o'clock tomorrow.
Yeah. Has been enticing. But 1778 at the bottom of the page, you will see that which formerly was in the guidance as regards exceptionality is now in the appendix to the rules.
Yes, well,
where an applicant doesn't meet all the suitability eligibility requirements, the decision maker must consider whether there are exceptional circumstances which would make a refusal of the application breach of Article 8. Unjustifiably harsh consequences. So you'd be familiar with that general approach. 7.2 is we can provide you with those paragraphs, but they are just general grounds of refusal.
yes,
So
well, we'd like to see the whole, but the bottom line is everyone is agreed that the substantive position remains the same.
Absolutely.
Yeah.
And then if you can go to the guidance, I'll do the same thing if I may. I can just give you references, if you like, to the guidance that was applied to us, and then show you the current guidance, if that would help.
Yeah.
The guidance that was applied to us is at tab 47. This is version 4. So page 1825, version 4, 9th of January 2020. And then if you look at, please, at page 1839, you'll see that under the list of ineligible sponsors for the purposes of family reunion.
You mean 1829?
1839.
39, sorry.
Page 1839, under the heading ineligible sponsors, in the antepenultimate bullet, you see a minor under 18 years of age would leave in any category, including refugee status. If a minor holds refugee status, they can't sponsor relatives under the rules, even parents.
Yeah.
And then, please go to 1842.
Sorry, and that provision has not gone into the appendix you've just shown us.
No, but it's there by default because the appendix simply provides positively for who can.
Sorry, I'm being slow. I may have misunderstood my lord. So we're looking at guidance now.
Yes.
Yeah.
The question is whether it's gone into the new guidance, isn't it? Or
New rules, I thought.
Well, no, I wanted to double check because of the way it's presented, it's not always clear to me which bits were in the old rules and or the old guidance and or in the new rules. And I just wanted to check that there's nothing in that bullet point that you've taken us to which has gone into the new rules. And your answer is nothing in that bullet point has gone into the rules. It's
Not in the
into new
rules,
guidance,
but it's in the guidance.
Yeah.
but it wasn't in the old rules either, was it?
Wasn't
No,
in the old rules
exactly,
either.
yes. It's never been in the rules.
Yeah.
But it's been implicit because. Yeah. Okay.
Yeah. The rules make provision for,
Yeah, we got it.
Yeah, we got it now. I just wanted to check that there'd be
Yeah.
no change at all.
and the guidance says not why.
Yeah.
So
now, are you about to show us the same provision in the new guidance?
before I do that, please, can I show you again in the old guidance,
Yes.
page 1842. So this defines ineligible applicants. Again, fourth bullet from the end: family members of children granted refugee status or humanitarian protection. And then across the page, parents and siblings of a child who have been recognised refugees are not entitled to family reunion under the rules. Where an application.
Sorry, just to be.
Sorry, I'm going too quickly.
This is just repetitious, really, isn't it? It's the same point being made under two different headings. What's the difference in substance between the antepenultimate bullet on 1839?
That is saying you can't have a sponsor as the child, and this is the mirror image of that, which is that the applicant can't be a family member of a child. Did you see? So this is
Yes, it's just saying the same thing.
It's the mirror image.
Two places. Yeah.
two places.
Yeah. Okay.
But then in terms of the approach, exceptionality, we have that here, or exceptional circumstances, a slight difference between the two, I know, in the case law. 1843, parents and siblings of a child to be recognised as refugees are not entitled to family reunion.
Sorry, 1843.
1843, across the page.
We've got exceptional circumstances with the heading at the bottom of the page, which always annoys me. But
If you look, I'm looking at the second heading, parents and children and siblings of a child recognised as a refugee. Sorry, the reference to exceptional circumstances was misleading because it's in the body of that paragraph, not in the heading.
Yes, I see. Thank you.
Do you see?
Yes, okay. Right
where an application doesn't meet the requirements of the rules, caseworker must consider family life, exceptional circumstances guidance, or consider whether there are any compassionate factors.
So these are hyperlinks.
These are hyperlinks, yes.
And where do the hyperlinks take you to?
I think they take you to as the guidance on Article 8. But again, we can provide
Is that right? I would guess the compassionate factors hyperlink probably just takes you down to the bottom of the page, doesn't it? Well,
we need
the whole picture. So
we'll address all of it compendiously. Sorry.
Do you complain about the paragraph under the heading parents and siblings of a child recognised as a refugee involving in some way a breach of Section 55?
Yes, of course.
Why? Because it does say each case must be considered on its own individuals and include consideration of the best interest of the child in the UK.
Because there's Supreme Court and Court of Appeal authority to say that the term function in Section 55 applies not only to individual decision making, which is what this speaks to, but the setting of the framework.
Yes, that's why I asked you if there was a breach, not whether Section 55 applied.
Yes,
I'm assuming your argument about Section 55 applied, but that says that when you say the function is making the policy says here, you must include consideration of the best interest of the child. So why isn't that, so far as the policy is concerned?
Because in setting the terms of the policy, in setting the framework, you haven't considered Section 55 at that, as it were, higher or anterior level. You can have
my question is obviously not being expressed clearly. We're just dealing with the words of the policy. When they adopt a policy, the policy must have regard to the best interest of the child. Now, we're not talking about whether they should have put it in the rules. We're talking about a policy. And the policy is you can take individual decisions, but when you take those individual decisions, you must consider the best interest of the child. So why is that policy in breach of Section 55?
Because the best interests of the child have to be taken account with a view to determining whether there are exceptional circumstances. And in setting exceptional circumstances of the test, in formulating the policy, it is common ground that the Secretary of State never considers Section 55 at that level. I mean,
is that common ground?
No.
Well, I think we must be at cross purposes. I've never understood there to be any suggestion that the guidance was in breach of Section 55. The guidance refers to Section 55, so it's very difficult to say it wasn't in breach of it. Your point is a separate one, but the rule that the decision making of the Secretary of State in relation to the rules is in breach of Section 55. And that's different, and that's not answered by saying that the guidance about individual cases is not in breach of Section 55.
No, that's right. It's individual decision making, no problem. In setting the framework, I don't restrict the framework to the rules, but also guidance. That's the function which the Secretary of State performs.
If we were to define the function as the discharge of a function of making a policy, that function complies with Section 55. Your real argument was that in fixing the rules, they haven't complied with Section 55. That's what I thought. I thought it was a simple point to check. I'm sorry I asked now, quite frankly.
No. It's a very good question, but
well, my lord, I clearly didn't intend to open up a can of worms at this stage when you were just walking us through. The position will become clear when we hear your substantive submissions.
yes, but can I just give you this nutshell?
Okay.
Which is that we say that Section 55 applies to the rule-making and policy-making function,
Yeah.
and it applies to individual decision-making. This paragraph speaks to the latter.
Okay.
But just going back to the paragraph I was on at the last two sentences, last two lines, not expected there be significant numbers granted outside the rules. Important evidence relating to exceptional circumstances is carefully considered on its own merits. And then the hanging title that my lord referred to, the bottom of the page, over the page, where a family union application doesn't meet the requirements of the rules, casework workers must consider whether there are any exceptional circumstances or compassionate factors which may justify a grant of leave outside the rules. And then midway through the next paragraph, compassionate factors are broadly speaking exceptional circumstances which might mean the refusal of leave to remain would result in unjustifiably harsh consequences for the applicant or family, not to constitute a breach of Article 8, but not constitute a breach of Article 8. And the next paragraph, the middle of the paragraph, entry clearance or a grant of leave outside the immigration rules is likely to be appropriate only rarely. And then those provisions are materially reproduced in the current version, which you have at tab 49, tab 49, 1893. And this is version 11, 9th of April this year. And if you can please go to page 1918. So under paragraph FRP 7.1, we looked at that a few minutes ago, actually half an hour ago, I think, where the application doesn't meet all the suitability or eligibility requirements under Appendix FRP, you must go on to consider whether there are exceptional circumstances, reference to unjustifiably harsh consequences, and then over the page under the heading unjustifiably harsh consequences. Once you're satisfied that family life exists such that Article 8 is engaged, you must consider on the basis of the information provided whether refusal would breach Article 8 because it would result in unjustifiably harsh consequences. And the next
For the applicant or their family.
yes. And the next paragraph, as mentioned in the application, I mean, this is with respect concerning, as mentioned in the application with respect of children, that's earlier in this guidance at page 1900, that heading takes you back, which rather supports what my lord was saying to me some moments ago. As mentioned in application with respect of children section of this guidance, the immigration rules take into account the need to safeguard and promote the welfare of children. Insofar as that statement is intended to refer to that in this context, it's wrong.
It's wrong because, well, your case is it's not wholly wrong, because one of the things it does is it says in taking individual decisions, you must have regard to the welfare of the children. So to that extent, it's right. But you say it can't pull itself up by its own bootstraps and say that it has regard to Section 55 when the structure under the rules provides for inferior protection for refugee children in respect to family reunion rights because it's dependent on the exceptional circumstances test. Is that, have I got understood why you say that doesn't
broadly,
work?
That's broadly correct, but there's a more profound reason that, if I may, and I think this is common ground. As far as the rules are concerned, it is common ground that the Secretary of State has never considered Section 55 in setting the rules. That's common ground between us. And that's
That's a little bit odd, all that, but don't try and make points. You're going to get there.
I'll get there. Yeah.
Yes.
It's the
But that, with respect, you're trying to make a point. I was just trying to put a particular point to you, and you're trying to make a different point on the back of it.
yes.
Have I understood the respects in which the statement that the immigration rules take into account the need to safeguard and promote the welfare of children is partly right, but not wholly right?
No. My submission is it's completely wrong. It's not at all right. It's not even partly right.
But
Well, all right. It's not. You say it's not right at all because although the Secretary of State does take into account.
I'm wrong.
Okay, thank you.
I'm wrong.
yes, you must be.
It's partly right because of the exceptional circumstances.
Yes.
Yeah. Sorry, my lord. I was being.
But the real point, as I've understood it, is that in deciding to have a different regime for refugee children from wanting to bring in their parents and siblings, from that applying to refugee adults wanting to bring in their partners and children, the Secretary of State, on the evidence, you say, never had regard to Section 55. So in deciding to set up that structure, and that's what this case is about, isn't it?
That's ground one is about that. Yes.
Yeah. Yes, exactly.
We
Okay.
also say that children seeking reunion and adults seeking reunion with the same people, members of the nuclear family, are similarly situated.
But that's ground two.
But ground one, yes, exactly, you have it right.
Yeah, okay, but that's fine.
You're
Well, let's
absolutely
keep going then.
But you're absolutely right. That's partly right. I was being anachronistic and thinking that exceptional circumstances weren't in the rules, but they are. So you're partly you were right to say, my lord, that this is partly right. And then the duty in Section 55 to have regard to the need to safeguard and promote welfare of the child in the UK, together with Article 3 CRC, means that consideration of the child's best interest must be a primary consideration in immigration decisions affecting them. The guidance and the rules it covers form part of the arrangements for ensuring that we give practical effect to those obligations.
And then it says, in conducting your Article 8 assessment, you must take into account as a primary consideration the best interests of any relevant child affected by the decision.
Yes, at the level of individual decision making. Yes, the same point. And then the judge accepted that this disparity had the following consequence. This is the judge at paragraph 72. My lord, I gave you the weekly law report version. I don't know if you're working from that.
I haven't received the weekly
Ah,
law report
you
version.
sent it through.
I took it off my own shelf, but I've marked up. the
Oh,
one here.
sorry. I'm behind. I've just been using the one in the judgment. It's been reported, has it?
Both
Yes,
now.
it's 2023 1 weekly law reports.
I see. Well, just give us paragraph numbers, but I'm using the one in the
I'm
the
so
core
sorry, my
bundle.
lord. It had was sent.
I'm not going to start looking at other versions
No.
now.
But
so-
I'll just give you paragraph numbers if I may.
Yeah.
So it's 72.
Have both judgments been in the weeklies or just the first one?
I thought they'd both been reported.
Oh, I wasn't aware that the second.
Okay, what? Just so I write it down. What's the reference for
first-
judgment one, the
first one is
earlier one?
2023 1 weekly law reports 4109.
Thank you. Okay, well, my lord's ahead of you about judgment two, but let's stick with judgment one at the moment. Which paragraph?
72.
Yep.
So the judge says the principal difference between an application family reading pursuant to those paragraphs of the rules, an application outside the rules, is that an application made outside the rules has to satisfy the high hurdle of showing exceptional circumstances, which is much harder for an applicant to achieve, generally requires more extensive factual and often expert evidence than an application made pursuant to those paragraphs of the rules, and is more stressful. The claimant's unchallenged evidence was that as a result, the families of some refugee children are deterred from applying at all, and that those who do apply are faced with far higher rates of refusal. A greater proportion of them have to go through the appeals process. Finally, family members will get 33 months leave, extendable, can have no recourse to public funds. In that summary, we would respectfully add that the lack of provision in and visibility in the rules means that many families, many refugee children just simply don't know about the possibility of applying for family reunion. And we see that at paragraph 75. His unchallenged evidence was that though he was granted asylum in November 2018, he didn't learn until 2020 that it was possible to apply for.
That's not because of lack of visibility in the rules, is it? I just don't know.
The evidence is from a number of experts in the field that many children simply don't know, that many lawyers don't know because it's not in the rules. And your lordship has the point about the extraordinarily Byzantine nature, not only of the rules but also of the guidance.
But if you looked at the guidance, it would be perfectly clear what the position was, and any lawyer would do that.
It would.
I don't know if this is your best point.
And then the impact on the appellant is at 77. Wasn't disputed as a result of his experiences. The claimant suffers from post-traumatic stress disorder, depression. Expert has prepared 3 reports. Graphic terms of the distress caused by being separated by the application appeals process. The expert's opinion is the separation.
Well, do we want 77? This is all about the individual case, which we're not
is reflective of. So in that case, if you'll allow me, I wanted to take you very, very briefly to an Amnesty International report which surveyed a number of children, and it's a very good place to see the kinds of trauma.
Nobody is suggesting, are they, or am I missing something? Nobody is suggesting that the difference isn't substantial.
No.
I'm just, I think just general introductory stuff that doesn't go to the legal issues isn't really helpful.
Isn't going to help you.
I don't want to stop you saying anything you have to say, but
in that case, I think it's enough if I simply, if you don't mind, if I just give you the references and just give you 2 headings. So it's Amnesty International, January 2020, the report headed "Without My Family," and that's at Supplementary Bundle 1, Executive Summary at 167, under, quote, the devastating effects of family separation. And then there's a more detailed section entitled "Without Family, like a body without a soul." And that's Supplementary Bundle 1, para 178 to 1.
I don't want to be misunderstood. You don't have to be. You don't have to be very imaginative to see how what the impact on children in this situation is.
Yes.
But at the end of the day,
of course,
we're concerned with the legal question here.
Yes, and this is relevant to the legal question, of course. Certainly on ground 2, because we
It
say...
might be relevant to justification if we ever get
Yes,
there, because
well-
the impact on this individual, had he still had a claim, would be relevant. Whether or not people who are not before this court and we don't have a victim other than this claimant is more debatable, but you would say it's part of justification.
I think, speaking for myself, be more helpful
Yes,
to
indeed.
deploy any materials you want to on the justification or rationality issues.
Yes, of course.
I'm not sure if it's in on rationality in my understanding of the argument, but can we do it at that stage?
Of course, my lord. I'm very happy to do it that way. And just on your point, my lord, no one suggests it's not substantial. The Secretary of State, just to reference her skeleton at paragraph 19, she accepts it as well.
Yeah.
But what you've got is essentially survivor's guilt, children suffering survivor's guilt, travelling back to get siblings, sisters, risks of re-trafficking and so forth. It's fairly harrowing stuff, I would respectfully submit. Ground 1 then, my lord. We say that the judge erred in his approach to function. This is our skeleton at paragraphs 50 to 70. We say, can I just give you nutshells and then develop the argument, if I may? So we say that he adopted too narrow an approach, requiring the Secretary of State to be actively considering a change to the policy of the kind sought before she could be exercising a function, with the result that repeated positive, JR-able decisions to maintain the status quo were not enough. When we see that from his judgment at 140, where he says the Secretary of State, 163 in your bundle, where he says the Secretary hasn't given active consideration since the 2nd of November 2009 to the policy option of changing the rules.
Did you do 140?
It's judgment 140, it's the page wrong. I was trying to be helpful.
Yes, I see. I find it, yeah. Yeah, okay, thank you.
So 140, because it hasn't given active consideration, the policy option of changing the rules so as to create a route to family reunion for refugee children. The issue of child sponsors was a ministerial red line. Now, in a nutshell, we say that the term in the statute, any function of the Secretary of State relating to immigration...
Well, it's the discharge of any function, actually, isn't it?
Well, yes, but the term any function, come on to discharge in a minute, but the term any function is a wide term which we say read in context, in accordance with its ordinary meaning and in purpose, given the purpose of the section, simply means that which the Secretary of State is permitted or required to do relating to immigration, asylum, nationality. And we say that includes deciding to maintain the status.
Sorry, can you go a bit more slowly? So I can
Sorry, my lord.
This is your substantive submission.
Yes.
That which the Secretary of State is permitted or required to do.
Relating to immigration, asylum, nationality. And that includes deciding to maintain the status quo, making a positive decision to maintain the status quo.
Well, okay, sorry. What's your formulation? Deciding or making a positive decision? They may mean the same thing, but I just want to be accurate.
I think they do mean the same thing. I'm just emphasising. It's got to be a
Deciding,
positive
okay,
decision.
i.e. making a positive decision to maintain the status quo.
And B, Mr. Pobjoy, operating a system.
So we won't ask you questions about that because Mr. Pobjoy is the target. Yeah, okay.
I've handed that to you. And our submission is that this flows both.
Sorry, just you said operating a system. I will ask you this question. That's a shorthand. Operating a system
for family reunion in respect of child refugees.
Yeah. Okay.
What does that mean? Well,
We'll wait for Mr. Popjoy.
Yeah.
And we say that flows from the language. It's also consistent with the case law. And we say that the judge, with great respect, misread the three cases upon which he relied in his judgment at 123 to 132. They were 3 million.
Well, you're coming to the cases in a minute.
I'll come to the cases. I was going to give you headlines, but if it's
No. Well, you've given us the headline. We know what the three cases are. We've read the judgment. Yeah.
would it be helpful if I gave you headlines about my submissions on the cases, or I can just do it
you've
in
got to do
one
it the
go?
way you want to do it.
Okay,
Mr.
so
Tendon.
headline.
One thing I do say about headlines is what tends to happen is
Yes, you're right.
is you trail them. We ask questions, and you then say, "Well, I'm going to come back to that more fully in a moment." So, if you want,
I'll do it in one go.
Okay.
And so. So I better go to the statute, in that, and that's at tab core volume 1, tab 1, at page 5. So section 55. We see it came into force on the 2nd of November 2009. You see that at the top of the printout. The judge also says that at paragraph 96. The commencement provisions, it's not in the bundle. I don't know if you want the commencement provisions or the statutory instrument, which...
No.
And then duty, section 55, duty regarding the welfare of children. 1, the Secretary of State must make arrangements for ensuring that. So it's a positive duty.
Yes, we've had a lot of submissions, obviously, about the later bits of this. We haven't had any submissions about must make arrangements for ensuring. It's a rather odd phrase.
Well, I think it...
But it's not been analysed in any of the authorities, as it. I had a quick look at the authorities I was aware of.
Not that we're aware of.
No, okay.
But it's interesting because it clearly... it's not simply laying down a negative obligation, but a positive requirement to make arrangements to ensure that the functions mentioned in subsection 2 are discharged having regard to the need to safeguard and promote the welfare of children who are in the UK, and B, provision about delegation, any services provided by another person pursuant to arrangements which are made and relate to the discharge of a function. And then 2, the functions referred to in sub 1 are any function of the Secretary of State in relation to immigration, asylum or nationality, and then B, any function conferred by or virtue of the Immigration Acts on an immigration officer, and then customs.
Well, we're not concerned with C and D. We're not really concerned with B either.
Not really concerned with B. Doesn't add anything because we know from House Laws Authority that immigration officers are called Carltona officials of the Secretary of State. There was a debate about whether they were or not. That went some years ago. So we're not really concerned about B either. But we say that these are very wide words and consistent with the purpose of the section, which is to safeguard and promote the welfare of children in the UK. Function means what I said earlier, i.e. anything the Secretary of State is required or permitted to do in relation to immigration.
Function may mean permitted. It may be a function if you do something that you're permitted. But if you're permitted to do something, but you say, well, I'm actually not doing anything at the moment, and indeed I don't intend to do anything, what function are you discharging?
Well, you're permitted to do that. You're permitted. The function of discharging is you're deciding to maintain the status quo, my lord. Different. It's different if you just don't think about it. But if you actually say, this is what I'm going to do, I'm going to maintain this status quo, it's a red line, that is the discharge of a function. Of course it is.
So if the Secretary of State's in his or her bath and thinks, oh, I wonder whether I should do something about the family reunion rules. No, I don't think it's necessary. That's an extreme example, but it's just tests. I mean, what you said, think about. I hope we need something more formal than that, don't we?
Our case is that you're certainly discharging a function when you make a formal decision that is judicially reviewable.
Well, that's circular, isn't it?
No, because we're saying that function includes decisions that are judicially reviewable.
Okay. I don't know, as soon as you think about it. So
It includes a formal decision which is reviewable to what?
Maintain the status quo.
So if I write in, concerned of Tunbridge Wells, saying, I don't like your rules, I've just seen the news, please change your rules, and the Secretary of State back and says, I have no current plan to change the immigration rules, thank you for your letter, that person can then say, well, you've breached Section 55.
Yeah. My principle is yes, I don't need to go that far, and of course my lords are going to be interested in what my positions are, what my submissions are at the level of principle, the level of theory. We don't need to go that far, but my submission is that.
Well, hang on. But you say in principle, yes.
Yes.
But you don't need to go that far.
No.
Why in principle? Just stick for the moment with whether that is a sensible construction in principle. It would mean that any individual at any time could create a decision by writing to the Secretary of State and saying, I don't like your rules, you should change them, and getting back the standard reply, we have no current plans to change the rules.
I think there are 2 points. The first point is that discharge of a function does not necessarily equate to a decision, and it does
Hang on, sorry. Okay, so
and it does not necessarily equate to a JR-able decision.
and what is the hallmark of a JR-able decision?
Something which is sufficiently considered and crystallizes the legal issues. So,
So if you make a sloppy decision, that's not JR-able.
Sorry, what I'm trying to say, something is, I don't mean in terms of how good is it. I mean a response, the bath, that wouldn't be formal enough to be a decision.
Well, but I'm trying to identify what is the hallmark of formality. Is it that there has to be a memo to the minister, and the minister's initials saying yes, no, or maybe? I mean, I haven't understood. You seem to think that calling it JR-able immediately plugs us into some recognised concept of a kind of decision that can be subject to judicial review. If so, I don't know what that. There must be this line of authorities I'm not familiar with. You need to tell me what you have in mind. If you're not meaning that, you need to be more precise about about what the touchstone is of something being JRable. That's why I thought it was circular, because essentially you're saying it attracts section 55 if it's JRable. But if there isn't some recognised touchstone for what's JRable, we're really back in the same question of trying to identify what's the discharge of a function.
Right. The reason... The reason we talk about JRable decisions being enough is for the obvious forensic reason that we've got JRable decisions, and we say, in our case, multiple JRable decisions.
Sorry, when you say you've got what?
In our case, as the judge held in his second judgment, he held that the decisions to make the rules, and in 2000, obviously at that point, Section 55 wasn't in play, but subsequent to Section 55 coming into force, the decisions not to actively consider changing them and instead to maintain the status quo were judicially reviewable decisions.
Where does he say that?
In his second judgment at paragraph...
Is that part of his ratio in his second judgment?
Yes, it's paragraph... So I've lost my note.
Possibly paragraph 30, I'm not sure.
That sounds likely, doesn't it?
I'm sorry, my lord.
That sounds likely.
30.
30. Which decisions is he there referring to?
I think he's referring back to his first judgment at paragraph 139.
But it goes via 23, subparagraph 2 of the second judgment.
I'm really sorry, my lord, I missed that. Yes, sorry, yes. 23.2. Sorry, if that's what you said. Yeah.
You've described a state of affairs, the maintenance of the status quo,
Yes.
which is another way of saying nothing has changed. You've added other words in front of that phrase, a decision to maintain the status quo.
Yes.
Now, when I read Section 55, it looks like what is called in the jargon a process decision. It requires a particular factor, the best interest of the child put loosely, to be taken into account when you're discharging your functions. From my perspective, because I'm very basic, it would be quite helpful really to look at the piece of paper that describes the discharge of functions or the decision that you say is this decision to maintain the status quo, which involves the Section 55 duty. So rather than looking at it in the abstract, nothing has changed, and calling it a decision not to change, it would be useful to look at what happened, which is why I said in the order, and you have done it to a certain extent, what are the things that you say, what events occurred, because then you can see whether those events are really the discharge of a function.
Yeah, my lords, I'm so sorry, I did not give you more assistance. The passage I was looking for was paragraph 39.
In the second judgment.
First judgment.
In the first judgment, the following written question was tabled in the House of Lords by Baroness Lister.
Yes. And then if you see paragraph 40, the Home Office Minister provides a written answer. And at 42,
Is that one of the discharge of the functions? Is the piece of paper with the written answer a discharge of functions to which section 55 applies? That's the sort of thing that would be helpful for me to know.
Yes.
To see. So paragraph 40 of the first judgment is a discharge of functions for the purpose of section 55(1).
Yes. And 42.
Incidentally, are these not ones that you have?
No, the parliamentary privilege.
Sorry.
Are you thinking of privilege?
Yes.
No, those are other ones.
So you haven't disavowed reliance on this one.
No, because we say that whilst the actual communication may be protected, the decision which ex hypothesi must be anterior to it, that's not protected.
But
But the only evidence of it is these passages which are
Yes, that's true.
protected. So how can we refer to the passages?
But as evidence of a decision that was taken.
But I thought we weren't allowed to refer to the evidence.
I think you are allowed to refer to the evidence as simply for factual purposes. You're not questioning or impeaching.
Is that right?
I think Mr. Pubjoy is familiar with these arguments from another case recently, and certainly there the speaker wasn't quite so relaxed.
I think it was Ms. Mitchell for the speaker, in fact. Possibly. No, that was another case.
One would have to look at paragraph 40 and see what the written answer means. You can be saying, is the minister simply describing a belief? Because it's a question about what have you done? And the answer is, what we have, we believe is enough. And wouldn't we necessarily be starting to question or tease out a decision to maintain from the answer that the minister has given? You've got to start questioning or interrogating the content of that 8 lines to see what the minister was saying. You might read it and say, I don't have to discharge my functions anymore. That which I have done is enough.
Well, I can sidestep that because we've got enough in the history. Can I just direct you to our skeleton? I see the force of what you're saying. If we look at our skeleton at 54 onwards, where we address the decisions made by the respondent, at 56.
Just give me a moment.
Sorry, no.
Yeah.
So at 54, decisions made by the respondent. At 56 of our skeleton, as the judge noted, the idea that nobody had thought about this was surprising because the Secretary of State had given multiple public indications that a review had been conducted. Didn't mean that she hadn't turned her mind at all. On the contrary, and then over the page at 57, responses to parliamentary committees, but we also rely on 58 on 2 further.
Hang on. So you're not pressing your allowance on para 57.
I don't have to. No.
Hang on one
The 2
second.
just
You
for
don't
your
have to.
notes.
You may have to if you don't win on 58. So it's not up to you don't have to. Is it or isn't it part of your case that each of these constitutes that which you have described as a decision to maintain the status quo?
Can I think about that and get back to you? The communications which we had disavowed are, just for your note, are at footnote 24, which were responses to private members' bills. That's at footnote 24. But at 58, we've got 2 further decisions. In 2016, the respondent decides to convert a blanket prohibition on children acting as sponsors.
So the function she's discharging there is to amend the policy guidance. Is that right?
Yes.
And the policy guidance that she adopted may or may not meet Section 55 instance. But if the function that she's doing is discharging the policy guidelines, and she's saying, I've got a policy, I want to change it, why does that mean she's taken a decision positively to maintain the immigration rules in their current form? Clearly she has, because she hasn't changed them. But why isn't the function that she's exercising the function of what guidance shall I have?
We would say that that is too narrow an approach to words that are deliberately wide words, and that you're required and permitted, you're required from time to time as the Secretary of State. That's the phrase in the statute. You're required from time to time, reasonable intervals, to lay rules.
Is that what Section 3 says?
Yes, we don't have Section 3 in the bundle, but the judge cited.
Hang on, this is quite an important new point, isn't it? If you're saying that there's a function based on a requirement, the requirement in Section 3 to lay rules from time to time, I haven't seen that anywhere in your judgment or submission arguments. It just popped into your head. If it is in your submission argument, forgive me.
No, it's not in the skeleton, but we would say what certainly is in the skeleton is rule making is the function, and deciding not to change the rule.
But all we know from your 58 is that she has changed the policy. We don't know whether or not she gave any consideration to the rules. Obviously, she's not decided to make the rules. The rules remain the same.
Yes,
but you're asking what function has she discharged?
She deliberately decided not to change the rules because.
Where is that evidence?
Mr. Bulchan's it's in our cited in our skeleton.
Let's have a look at what Mr. Bulchan said.
Mr. Bulchan's. So it's actually not that helpful because he just says the submissions are correct.
Well, all right, but
you need to look at the
nevertheless,
submissions.
that is the evidence. We can cross
So you need to look at the submissions.
Well, we need to do both.
Yes.
Let's
So
just see
Mr.
exactly what he
Bulchan's,
said.
Mr. Bulchan's is at
It's in supplementary 1.
supplementary 1.
I think it's tab 30.
Thank you very much.
Page 322. It was rather concealed from us because it didn't have its own tab, but we've got it.
Yes. So he says at paragraph 5, top of page 323, I confirm the position as set out in paragraphs 9 to 11.
Yeah, so then we have to go back
If you
to
go
page
back.
320.
Exactly.
Let's just read that again.
If it isn't aware of any occasion since section 55 came forth where relevant decision makers decided to review the rules in order to consider providing a route to family reunion. Records since 2015 indicate a consistent position of relevant decision makers as communicated to officials has been they are not prepared to change the existing long-standing policy of considering applications for leave on a case-by-case basis outside the rules. Thus, for example, ministers were clear changing the policy was not one of the options to be included in the new plan. Paragraph 11, position before 2015, a search has been conducted. Secretary of State has been unable to find relevant communication from ministers to officials dating back beyond that date. So,
well, it's nice. It's nice and stark. It's clear the question came up from time to time whether to review.
Yes.
And they said no. That's off the table. It's a red line.
Consistent. Yes.
You say that's a decision.
Yes.
Or more accurately, you say it is the discharge of a function
Yes.
in the form of a decision not to review. And the Secretary of State says, no, it's merely a maintenance of the status quo. That's not a discharge of a function. You might call it a decision to maintain the status quo, but it's not a discharge of a function. It only becomes discharge of a function if you do,
Yes.
well, certainly if you do change the rules,
Yes,
possibly if you do set up a formal process to decide whether to take the rule, to change the rules,
yes,
and
of
then
course.
decide not to.
Yes, yes, of course. So
So that's really where the battle lines are drawn.
that's where the battle lines are drawn. 2 points I would make. One, you can maintain the status quo by positively deciding to do that, or by default. And we accept that you've got to positively decide. You've got to.
Default is sufficient to constitute a discharge of function.
No.
Okay, sorry. You can You can maintain the status quo either by a positive decision to do so,
Yes.
or by default.
Yes.
But only our case is only that the former
Yes.
is the discharge of a function,
Yes.
and or
Yes.
JRable, because it's the same. Is
Yes.
that right?
Yes.
And or JRable. But it is our case on the evidence that there was such a positive decision,
Yes.
or multiple. There were multiple such positive decisions. Yeah. What's your best
And the
case
second-
as to, ignoring ones which have a problem of parliamentary privilege,
Yes.
what's your strongest example of whether you say the evidence shows, contrary to what Mr. Ulches says, a positive decision to maintain the status quo?
We don't think that is contrary.
All right, fair enough. Okay, but contrary to his characterisation of what it is.
I'm going to. Can I come to that in 30 seconds?
Okay.
Answer you in 30 seconds. The second point I was going to make is that otherwise it is very easy for a minister to frustrate the evident purpose of Section 55.
Well, that begs the whole question of what is the evident purpose of Section 55?
Well, we know it was to domesticate Article 3 of the CRC.
Well, we haven't shown us Article 3, which isn't in the same language as the statute.
It's not quite in the same language. It uses the word
Okay.
action. I accept that.
And the other problem that you've got is what you're trying to do at the moment, it seems, is to turn an obligation to have regard to a particular consideration when you discharge a function into a different type of obligation, an obligation to review or decide whether or not to discharge the function.
Yes, because if you don't do that, then there's nothing on which the duty to discharge can ever bite. And,
Well,
and standing back-
that wouldn't normally be so, because this whole state of affairs only arises because of the happenstance that the family reunion rules were made at a time before Section 55 was in force.
yes,
If it had been the other way round, that there were no family reunion rules, or new family reunion rules were introduced after Section 55 came into force, then Section 55 would unquestionably bite.
yes,
You're saying,
but in a way,
okay, that hasn't actually happened, but things which are substantially equivalent have happened.
yes.
And I was just asking for your best examples. So
Right,
one is
so I better
clearly
give you that. Yeah.
58.1, which you were addressing us on, I think, when we went off on this point.
Well, 58.2 is probably the best one, because the Secretary of State reviews her position, it submits a query in February.
Let's just have a look. Let's have a look. Yeah.
So she submits a query. across EU member states in February 2018.
She submits, I just didn't hear,
An ad hoc query.
a query, yes, I see.
I'm looking at 58.2, my lord, in my
Yes, no, I just didn't hear query.
Which
Submits a
records-
query, yep.
Sorry, my lord. Which records that she is reviewing, quote, the policy on refugee family reunion and listening to concerns from NGOs that the current policy and immigration rules on family reunion are too narrow.
Do we really need to look at the documents rather than an extract from the document if you're saying that that thing is
Well, it's the
a
response.
decision? We'd have to look at the
Well,
document
that's the build-up.
and we'd have to look at the response.
Yes, well, that's the context. And then also, so that tells you that she's seriously thinking about it. And given that she does not do anything in response to that, we say that is a deliberate decision to maintain the status
So
quo.
we can infer
Yes.
a deliberate decision as a result of the 2018 exercise
Yes.
to maintain the status quo
Yes.
as regards child sponsors.
Yes.
Sorry.
Sorry.
I see the judge explains this in paragraphs 43, 44 of the judgment by reference to an EMN ad hoc query on evidence. So what is such a thing?
That's a query sent to member states of the EU, which he then addresses.
Well, have we not? I thought we had it. I haven't looked.
also
I
got
thought
it.
we were going to be taken to it.
Yeah.
But it's in the supplementary bundle, isn't it?
It is. You
Well, can we not? I don't. Annoyingly, I don't think, unless I've misunderstood, the reference is in the.
No, it's not.
Just, there are some references, but they're all to the core bundle.
yes, that which is to the judgment itself. So that just.
Is it not tab 22, or no, sorry, tab 23?
On numbers, it's page 1256.
12,
Sorry, 246.
246. Yes. Okay, well, we've got it.
This is the Belgian. That's the Belgian.
Is it? Oh.
There were
No,
two-
surely this is the UK one. If you look at 247, the UK are
Sorry, I'm
currently
in the
reviewing
wrong
the
page.
policy. That's what your quote is
I'm in
from,
the wrong
isn't it?
page. You're right.
And then asked a number of questions,
So if you look at 247 at the top, the UK
which
are
is what I'm looking at.
sorry, currently reviewing.
Can I just understand this? Can we go back to 246 rather than just take words out of context? So, the United Kingdom, somebody from whoever EMN NCP is, asked a question on the 27th of February 2018, and that goes into some European database. Is that correct?
Yes.
And then we've got responses from Austria, Belgium, and all those other countries there.
Yes.
And then we've got a disclaimer saying they are provided for the purpose of information stage. So over the page we have background information. Who has prepared the background information section of this document?
Well,
That's the
I
background.
think this is a
question.
document putting under the auspices of the European Commission. You see that from.
No, I don't think that can be right, can it? Well, of course the whole thing is, yes. But surely what generates this document is somebody in the UK asking a question.
Yes.
And presumably the background information, that first paragraph, is
From the UK.
quoting from someone in the UK.
Yeah.
You see that from the second sentence.
Yes,
Sorry, the second paragraph. Our published policy.
yes.
But
But we don't know exactly who. We know if 246, it's something called the UK EMN, which is the European Migration Network, NCP. I've no idea what NCP stands for. Mr Giovanetti, do you know the answer to this? This
Find out.
We'll find out.
I mean, everyone has assumed, I think probably rightly, but we need to nail this down, that this was effectively a Home Office generated inquiry, some entity within the Home Office.
Yes, that was the evidence.
But it would be quite useful to know who. But I think there's no real evidence. You said that was the evidence, but there wasn't any evidence from the Secretary of State, was there? We're all just having to infer from these documents.
Yes, I think that's right.
So somebody,
Mr Anderson's about to tell you the answer.
Sorry, it was simply that NCP is National Contact.
National Contact Point. What is that? Is it a department within the Home Office? Is it a section within the Home Office? Is it a civil servant? Or what level of seniority?
Those details, my lord, I don't have, but each state has a national contact point for...
It must be someone in the Home Office. Realistic. I mean, speaking for myself, not necessarily for my lords, unless there is any evidence to the contrary, we must assume that this is a ministerially authorised query in support of a ministerially authorised review. That's the natural inference. You don't go asking questions to the European Commission otherwise. Sorry?
We will see if we can take instructions on that.
Well, you can take some instructions, but we won't necessarily be bound by the instructions, because this is a matter on which there would have been evidence.
yes.
But that's the inference I would draw from the documentary evidence. But nevertheless, by all means, see if you can get some instructions. Right, well, because this is an important document to your case, it's important we know all about it. But I imagine you are happy with the inferences that I said I would draw. So that's it's not really so, and then the questions are presumably also drafted by the UK. And 5 is the key question, isn't it? Do you allow children recognised as refugees to sponsor relatives for the purposes of family union? If yes, when, what impact did it have, and so on?
The problem that I've got is you're saying, and this is evidence, or you can infer a decision to maintain the status quo, but a lot of this seems to be at a much more general, not is it immigration rules or policy, which is what you're concerned with. This seems to me more general about pull factors. What's causing people to come? Why are people coming? Is it because children are allowed? Not whether should it be in the rules or should it be in policy, but what's your experience?
Well, with great respect, no. If you look at page 247 and read the first sentence.
Review the policy.
The UK
The current policy and the immigrations are too narrow. They don't have enough. They're not generous enough and don't allow enough in. But that's different from the debate that
They
we've
don't
got.
allow children to sponsor.
Yeah,
Family
you would say that that's really the inference from question 5.
Yes.
Yeah, very well.
And that's
Okay, and then we don't need to see, but from our point of view, it's not, doesn't matter. I mean, you may come back to it in some other context. It doesn't matter what all the countries answer. No. The point is that this is evidence, you say, of a Home Office review of this question as relevant both to the rules and to policy.
Yes.
There is no evidence of what decision was taken, but you say the fact that no change was made must mean that at some point a decision was made not to change. Is that your case?
Absolutely.
Right. And I'm right, there's no further evidence. We don't... you do refer to some...
There's not evidence, but there's a response to a Part 18 request in the same bundle of the 2nd of October 2024.
Hang on 1 second, let's not take a minute.
Which page is that?
The response is at page 369. And the bit that I would like you to look at if you see, do you have that, my lord? Then if you look over
Yeah,
the page,
but that's any time slow. 369.
uh,
Helpful to have the tab always, but yeah, okay, I've got it. Thank you.
and then if you look over the page at 370, under D, the decision described at 4.2, I'll take you to that in a minute, but it's the same thing that we're looking at in the context of a 2018 review.
Sorry, I'm getting slow. What was the question?
Okay, I should do it that way. It's a bit stupid of me to
What's the question?
The question is at 366. Sorry, that was silly. Paragraph 4, 366. Paragraph 4, the appellant also relies on two further decisions as follows.
Yeah.
4.2, in 2018, the respondent reviewed her position on family union. That is apparent from the context of the query that we looked at. And then if you look at, if you flick back to 370, sorry, we say by necessary inference the respondent made a decision to this effect, i.e. not to change, either before, during or following the review. That's the inference your lordship was prepared to withdraw. That inference is confirmed at 370 because it is said by the Treasury solicitor after July 2018.
Sorry, just to be accurate, I've looked at 366 and those are general statements. The request was 367, just so that I've got it clear, which request is the one that follows from this?
7D.
It's 7D that we're looking at, okay? So you
And the question was, can we have the date?
Yes, exactly. So the question was, can we have the date of that request?
Yes.
And the answer is you're going to tell us at 370.
370 after July 18. And this was because your lordship had said, can we provide dates?
Yes, well,
Remember.
I asked you what decision, or asked for the information on what decision and what dates, rather than general stuff. And the answer is October 2016, is it?
No, after July.
After July 2018.
Yes.
So
So she's saying there is a decision taken after the 18th of July.
Yes.
After July
yes,
18.
in a sense, the request assumed that there was a decision, but she didn't reply saying there was no such decision, so we can't answer this.
Yes, exactly. Well, that's your best point then, isn't it?
Yes.
Well, you've got another point under 58.2.
Yes. Which is a response to the independent. Yes, and more evidence. Ms. Mitchell helps me. It's more evidence of the same review.
I see.
Yeah.
Yes, I see. Okay, so
But,
yeah, okay, that's very helpful.
but just to go back to about the statutory purpose point that I was making before, your lordship said, well, that's bootstrapping, I'm begging the question. So standing back, one would ask, can Parliament seriously have intended for the Secretary of State to avoid, sorry if I'm using loaded language, but for the duty in Section 55 not to be triggered in this context over some 16 years or so?
Answer, always dangerous to ask a rhetorical question. Yes, because you look at the word of Parliament and Parliament didn't say, and shall periodically ensure that all previous decisions
That would
taken.
follow, that would, well, not just all previous decisions, but
in the
that
discharge
would
of-
follow on a literal approach to the language. I accept that, but it does not flow from a contextual or purposive approach to the language, or a sensible approach to the language. There is a power generally to exercise functions, and that power should not be exercised by ministers to.
But at what point in the 16 years did it become obvious that the duty under Section 55 had been triggered then?
2018?
Ah, but that's because you passed a
All right.
decision.
By example,
Can we just see where we have got to? some of the more extreme ways in which you have been putting your case aren't really necessary to you, are they?
They're not. No, they're not. They're not. I hope I was making clear that there's in principle position what is the function, and then on the facts we've got it, we're well in whatever the boundaries are, and I don't think the boundaries are easy, but by way of at the matter of principle, I would say function is very wide. Any function relating to those.
Right, but
You've got all those
see
points.
that produces results which the court at least, and indeed the judge,
can-
found very uncomfortable.
I can.
But your more modest, but you say perfectly good case is that whether or not you're discharging a function any time you don't make a decision to change the status quo, at the point when you undertake a formal review and by inference but unchallenged inference decide not to change as for having conducted that review,
Yes,
that at least is the dischargeable function.
absolutely, my lord. Your lordship has our case. Yes.
The 2018 is your best case because the review in terms is described as relating both to the rules and to the policy.
Yes.
Can I just at this point introduce something which, if I were counsel, I would probably stop from doing, but as I say, it's not pleaded. It's more a point for Mr. Giovanetti to deal with than for you. At the point, I forget, is it 2021 or 2023, when the exceptional circumstances are taken into the rules rather than treated as a policy outside the rules, would that attract your concept of an effective decision not to alter the status quo? You are, after all, altering the immigration rules. It hasn't been put that way.
That's even more strong.
Well, it's stronger in some ways and not in others, because as everyone agrees, you don't actually affect the substance. No.
Which rather supports the idea that Parliament couldn't have intended Section 55 to turn on whether or not policy was being made and published in guidance on the one hand or in the rules on the other. We have Alvi, and we understand what needs to be in the rules and what can be extra rule. But at the end of the day, in substance, immigration rules are executive statements of policy subject to legislative imprimatur through negative resolution procedures. They are.
We know what they are, Mr. What point are you making?
The point I'm making is that there's no magic in the fact that the Secretary of State decided to put exceptional circumstances into the
Okay,
rule.
well, that may be an answer to my point then.
Sorry, my lord. It makes the point even more strongly. I mean, it's in 2025. I should say. I think it only occurs last month. Is that right? Ms. Mitchell, I'm sure she's right, suggesting that it may have happened in 2023. I thought it was just 25. Maybe that's
I made a note
the
for
most
myself, and
current.
I thought it was 2023, but I could.
You may well be right.
I thought it was the 12th of April 2023.
You didn't. This isn't your pleaded case, then, so it's not in your claim form.
No, this is. I
reason
aimed
is-
off at the beginning by saying this is a bright idea from the bench and therefore probably wrong, but I just wanted to test it.
Well, can I just ask one question? Because in the order, I went to some pains to the information for the parties to identify specifically the Act's decisions and the dates. And in your skeleton argument, have I missed it? You haven't relied on this, not even in your skeleton argument Having
On
been
this,
prompted, yes.
Well, the reason we haven't is because it post-dated the claim form.
Right. So that's okay. So you
The
understood
first
the-
hearing was
okay.
was in June 2022.
Right. But as a
week
practical
after the
matter,
one
I
one.
haven't missed something in the skeleton.
No.
Whatever the reasons for it, you haven't relied on the fact that the rules have changed in 2020.
This is me
An Underhill special.
thinking about the case.
Yes.
Thinking about the case as it is now, because the importance of this decision is for the future, not for the past.
Yes. Yes.
And in exploring, without prejudice to whether it's a point you're entitled to take, exploring where your argument would go. I wondered whether the making of the new rules on the 12th of April 2023, where this family reunion, this exceptional circumstances limb to the family reunion policy, becomes part of the rules for the first time, but is substantively the same as the previous policy, whether your reasoning would apply to that. You say it would.
A fortiori.
Yes, well, Ms. Giovanetti, in addition to saying it's not open to you, may also say it's wrong anyway. But I'm not sure it's a fortiori, just for this reason, that although in one sense it's a fortiori because it's formal, you are making a new rule. But the new rule simply reproduces the language of the old. So the Secretary of State may be said not to have been reviewing the substance of her policy. She was merely reviewing where she put it.
But my lord, I will respectfully respond to some part of what you said by simply saying the discharge of functions isn't simply making rules; it's also making policy.
Yes, but the policy is the same.
Yes. So why should it make all the difference that she's made this rule? I see you're thinking about the change. There's a change between 2011 and 2016.
Ah, yes, okay, but this is probably a red herring on my part, but it was going through my mind, and I wanted to just get your views on it. I'll get Ms. Giovanetti's as well, but talking about 2011 and 2016 is a different point. This is about the 12th of April 2023.
Right. So the 12th of April 23, something is put in the rules. I'm sure my lord's right. Something's put in the rules that used to be in the guidance. We say that it should not make all the difference that the Secretary of State is making a rule as opposed to making guidance or maintaining guidance.
But from your
because
point
both
of-
are species of policy. Sorry, my lord. I was going to.
From your point of view, it's better, it helps you, because you can say the one thing that you was doing on the 12th of April 2023 was exercising and discharging the function of changing the rules. She actually did that, and she included certain things in the rule and didn't include certain other things in the rule. And you would want to say, I would have thought, not that it makes no difference, but that it's better and stronger, that that's a clear discharge of a function of making the rules, and therefore Section 55 applied to the exercise or discharge of the function on that occasion.
That's why I said it's a fortiori. But if my lord was driving at the point that there's a change, something new's occurred, well, there's a very clear example of something new occurring in the guidance, because the judge referred to this, and we can see it in a minute. There was a step change from 2011 in the guidance, which made no provision whatsoever for child refugee sponsors, on the one hand, and July 2016.
Yes, well, is that another of your examples then? Where's that in the skeleton? I think.
I'm sure it is. But
Is this your?
that's another example.
Is that your 58.1?
Yes, exactly. Sorry, thank you very much.
But what will be said against you and you need to address is you can't just say anything that occurs in the immigration field is discharge of function in relation to the immigration field and imposes a duty to consider changing the rules. Don't you have to show that the function is a function relating to the rules? And I'm sure Mr. Giovanetti might want to say 58.1 is I exercise the function of amending the policy guidance. But I didn't consider and have never considered at that stage amending the rules because our position has been
I
not
think
to.
my lord put this point to you, according to my note, about half an hour ago.
I've forgotten.
And I've got your response.
What was
Yes.
the response?
You have my
Too narrow an approach.
Oh, right. Okay.
Yeah, well, because it's things that the Secretary of State does, is required to do and permitted to do, is not simply making rules. We know that from Alvey. There's certain things that shouldn't be in the rules, certain things should be in the guidance.
Yes,
It has
but,
an
but
extra-
your case here, the guidance, your case here has to be targeted on the rules.
On ground one,
Yes.
no, I would say no. Because it can be, it's enough for me, but I don't have to. It can be, the proper target of it is the policy.
Yes, I see. Is your point that, well, I think it would have to have been in the rules because of Alvey, but if your point is that you would have no cause for complaint, or there'd be nothing wrong in law in the Secretary of State having a policy not incorporated in the rules that allowed child sponsors to bring
Yes.
their nuclear family, to use
Yes.
that shorthand for the moment,
Yes.
in on substantially the same basis as adults. So that's why it doesn't have to be in the rules.
Of course.
It probably would have to be in the rules.
It probably
because of
would, but
Alvey.
that would be a different point. The argument would be, you're Alvey non-compliant. But,
But you're recorded by the judge as having said your real target was the rules. And I
Because-
rather assumed that was so.
oh, because of Alvey.
Yes, I see.
But that's not our, I mean, my case on ground one absolutely is not restricted to the rules. The Secretary of State has general statutory discretion under Section 3 of the 71 Act to permit...
Well, okay, can I write this down, see if I got it? My case is not based on a decision to maintain the status quo under the rules underlined as such, but on a decision to maintain the status quo as a matter of policy, including by mere, as a matter of policy. In practice, any change of policy in response to a change of policy of the kind sought would have to be in the rules. But that's not the essence of my complaint. Yeah?
Your Lordship, if I may, has it perfectly. Thank you very much.
Okay. Right, where do we go now? Oh, I think we've made some progress. You have given us your two best cases, possibly for the reason to which we've now just gone back to. The 2016 episode is not quite as clear for you as the 2018 episode, but you say the 2018 episode evidenced in the two ways in the skeleton and supported by the
Yes.
further information. You say unquestionably shows a decision to maintain the status quo
Yes.
in the rules.
Yes.
Okay.
After
Do you need to say anything more about that, or do have we got a lot of ground still to cover?
No,
We haven't yet looked at the case law.
But I can deal with the case law fairly.
Yes, I mean, if you're right
quickly.
about this, a
Yes.
lot of the case law doesn't really worry you, but we need to look at it perhaps briefly since it's part of your case.
You would like to look at it. I need to neutralise this.
Yeah. I was just trying to find out what the judge said about the 2018 review, and it seems to be left hanging in the air. Paragraph 44 of the first judgment doesn't refer to the further and better particulars, and the decision was after July 2018. It simply says it referred to review which said to be current. Neither party provided any evidence as to the progress or outcome of this review. 44 of the first judgment.
Yeah.
That doesn't refer to the further and better information that you've just taken us to. And then there's a list of things at 1112, and he seems to think the review hadn't come to an end. And then at 1127, 1126 and 7, he refers to the request and the Home Office response to the report. But I don't, unless I've missed it, see where he deals with the inference. There must have been a decision after July 2018.
He comes to a conclusion in 1394 and then 140, I think.
1394.
Yes, exactly.
Oh, yes, I've underlined that. So what does he say?
So he thinks that the witness statement confirming the paragraphs undermine the reliance on paragraph 1394, I think.
Yes.
And then the question is, can you reconcile the witness statement of the paragraphs with your case on the 2018 request? And I think it's possible you can.
Yes. Yes, we would say you can. They're conducting a review, they're giving deliberation, and then at the end of the day, they just say no. There's the red line.
I mean, specifically, the Secretary of State says in the paragraph which is confirmed in the witness statement that the Secretary of State is not aware of any occasion when the relevant decision makers decided to review the rules in order to consider providing a route that was more favourable. So perhaps they weren't thinking about reviewing the rules to provide a more favourable review.
Exactly.
But perhaps they were nevertheless thinking about reviewing the rules.
In our submission, the approach of the judge is incredibly narrow, because it's not enough that they were reviewing the rules, but for him, with respect to him, they've got to consider introducing the kinds of provisions for which we contend. That's the real one problem and one error in his approach, we say.
Well, it's not.
It's
Not even that. I think you say that would be the inevitable consequence of doing that.
Yes.
But really, if there were a bit of paper which said, in sometime in late 2018, say, I have conducted the review has come to an end, and its recommendation is whatever it is. I, the minister, have decided not to make any change, which would necessarily include a change to allow child sponsors. In making that decision, I have had regard to the best interests of children. In order to be defensible on rationality or public law grounds, it might have to have a little bit of text saying, I realise that this would be in the interests of child sponsors, individual child sponsors, but it's outweighed by ... Then you'd be dead in the water. But there isn't anything like that.
No.
But that's all that would have to be.
I mean,
That would all that had to be on for Section 55 grounds.
On ground one.
On ground one. You might have
it's
to
a
have
process duty, but you've got to. I mean, it's not a tick box. The Secretary would have to confront.
Well, in a sense, it is a tick box. It's a process duty. It's not a substance.
Yes, it's a process, but that's
if he reaches a decision which is perverse or irrational, then there are other public law grounds. But the point is that would show, unless it was a sham, but that would show that the minister had regard to Section 55.
Yes.
Might have reached an unsustainable conclusion that it didn't require any different policy, but that would be a different ground of challenge.
The first thing he would have to do is identify the relevant cohort. That's children in the UK. See the statute.
Yes, of course. That's why I said there'd have to be a little bit of text showing that you had actually I forget exactly, there's something in the case law that says you can't just say I've had regard to section 55, you've got to show you've identified the relevant interests of the children.
Yes.
But when it then comes to what you do as having identified them, then rationality and or perhaps discrimination.
I accept it's a process duty.
Well,
Process duty. I think it's a citizenship fees case.
Okay, and can we just be clear about this? If you succeed on ground one and only on ground one, we'd have to consider about it. I have tried to find, but I haven't found anywhere in your skeleton argument or pleadings an identification of what you say the result would be. But all you could ask for, and there might be reasons put forward why you won't get even this, but would be a declaration, not necessarily an order, but the declaration would do, the Secretary of State has to now reconsider the decision taken in, let us say, 2018 or 2023, whenever it might be, having regard to Section 55.
Yes.
You might then get the same answer.
Yes.
Yeah, okay, well that's clear. That's the appropriate relief for ground one, is simply that the Secretary of State reconsiders having regard to a factor which on the evidence he or she failed to take into account at the time.
Yes, it's a classic process challenge.
Ironically, we'd be quashing a decision which we've never seen and whose date we don't know.
You don't have to quash it.
We don't have to quash it, but that would normally be what would happen.
You don't have to
but that's
quash
what's happening. We're saying the decision that was taken is unlawful and she's got to retake it.
Yes, I hadn't actually assumed it. I hadn't. You might ask for it to be quashed on the basis that it was taken in without an irrelevant.
That's the normal remedy.
Yes, I suppose so.
Lots of authority to that effect. Textbook saying it.
Very, very good text.
But you could, as an exercise of discretion, say it remains in place until you have reconsidered. So there's got to be a policy of some sort.
Well, that
we reflect.
creates another big problem. I'm just.
Well, let's cross that bridge when we come to it. I just wanted for the moment to flag up, so we're clear in our own minds what the consequences of success on ground one only are, and they are the consequences we've been looking at.
Yeah.
Thank you.
We won't get into prospectivity and quashing all.
No, well, we can deal with all that later if necessary.
So the cases, the judge relies. Firstly, on the 3 million case.
Yes.
My Lord Justice Lewis will recall. What we say about that, before you take it up, is that in that case, nobody had turned their mind to the issue of arrangements. Nobody had turned their mind to the issue of arrangements for EU citizens to vote, to register to vote in the parliamentary elections post-Brexit. This wasn't a positive decision to maintain the status quo case. It was, as it were, I haven't turned my mind to the issue case. And you have that in volume 2 of the authorities, 3 million, and volume 2, tab 27, page 1128. And if I can go to the heart of, to the passage upon which Mr Giannetti relies, and we have that at paragraph 130, at page 1161. When my Lord says that some examples of the issues the pleadings evidence appear to leave unanswered can be readily identified. The duty is a duty on the authority to have due regard to certain matters in the exercise of its functions. I should have said this is, of course, the section 149, 2010 Act, Equalities Act duty.
But everyone seems to agree that the principles are the same.
Yes.
Well, the language isn't identical, but
It's not
substantially the same.
Exercise on the one hand and discharge.
Yeah, okay.
In relation to the making of regulations amending the 2001 regulations, a real issue as to whether the defendant was exercising any functions in that matter after June 16. Regulations are made quite possibly when the issue of whether to amend regulations or not is being actively considered. The Minister may be exercising functions. The Minister will need to comply with the PSED.
Well, we can read it ourselves. What's the point you want to get out of it?
The point I want to make is that this is of limited assistance to Mr Giovanetti for the following reasons. Firstly, it's an obiter passage with respect to my lord. The court didn't decide whether there was a breach or not. It gave no relief because the regulations have been repealed. There would be no more elections. The judge noted that at para 124 of his judgment. Secondly, even on an obiter basis, my lord didn't conclude that no function would be exercised, save in the scenarios identified. Your lordship expressed doubt on the point. Thirdly, the factual background against which those comments were made is very different here. The challenge there was to compliance with the PSED as it related to voter registration arrangements in 2019. The function identified was planning and making arrangements for those elections. We see that para 64. And the challenge was that the public authority had failed to engage properly and in good time with the legal requirements in carrying out electoral functions.
I think if you look at 125, you'll see what the complaint was about.
That's
Between
right.
2016 and 2019,
Yes.
various flaws in the arrangement for European elections have been identified, and was said they didn't gather information to rectify those flaws.
Yes.
And the fact of the matter is, after 2016, everyone thought we would have left before the 2019 elections, and for events that are now historic but well known, we didn't leave until the 31st
Yes.
or the 30th of December 2020, and nothing was done, and nobody thought about doing anything,
Exactly.
simply because they thought it would never happen.
Yes. So there was no positive decision. We see that from my lord has said it. We see that from para 36.
Yep.
And the defendant only realises late in the day that withdrawal wouldn't be complete. We see that from the following paragraphs, 37 to 47. So it was in that context where my lord doubted whether any relevant function had been exercised. The key differences here are, we say with respect, obvious, no evidence of the defendant having made deliberate, reviewable decisions, refusing to...
Okay, well, we've got the point.
You've got the point.
Yeah. Okay. Well, what's the next case you want to take us to?
The next case was Badmus. Badmus is a... I don't think I need to take you to that.
Okay.
But it's relied upon by the judge. I can simply say that is a case which is unarguably the right side of the line, because the defendant was looking at a policy choice between four options as regards remuneration of immigration detainees. What what Badmus shows is what is sufficient for the discharge of a function or the exercise of a function, not what's necessary. It's not setting our cases. It's not setting out, not purporting to set out what the outer limits are. And then I was going to take you to Adiatu.
Yes.
So Adiatu is at, it's again a PSED case. Adiatu is at tab 23 of the same bundle that you're in at the moment.
Yeah.
And again, in brief, this is different to our case because what the defendant magistrates treasury was doing in that case was considering changing the status quo.
So we're considering changing the status quo.
Yes.
Yeah.
PSED undoubtedly attached to the exercise of that function. This is in response to COVID lockdown. The claimant, the individual and his union, were contending that D was required to address the equality impacts not of the status quo or any of the other alternatives that were under consideration, but of a further option not under consideration. So that's more about the content of the duty rather than when is it triggered, when are you exercising your function, when are you discharging a function. And our case isn't that that under Section 55, what the Secretary of State has got to do is to consider how much better our proposal would be, unless that's on the table. But what she clearly does have to do in our submission, and this is more than sufficient for our purposes, is to consider how her existing system impacts on best interests. So Adiatu, we see that this is, again, PSED case. From the holding at page 960, we see this is a challenge to the Treasury's response to the lockdown, specifically that statutory sick pay and the job retention scheme, which provided for furlough, didn't cover those in the first claimant's position, i.e. those who did not earn above the lower earnings limit, the LEL, those who weren't within the PAY system, i.e. Lim B workers. Claimants submit the decision to exclude Lim B workers from the JRS, not to raise SSP or to remove the LEL were unlawful. Those are options that were not on the table. And one of the grounds of challenge is that the PSED was failed to be complied with. And if you look at 962 letter J, that's his the third holding, that argument failed because it doesn't apply to primary legislation changes. But what the court says is that the focus has to be by reference to the changes actually proposed and implemented, not what claimants would have liked, that is to say extension of SSP to all Lim B workers and so forth. And then if we go forward to paragraph 199.3.
250-page judgment delivered 4 days after the hearing. Pretty impressive.
Indeed.
Don't think I've ever had one of those myself.
And during the lockdown.
Don't raise your hopes for this one. And during the lockdown. Well, maybe that had something to do with it.
Well, that really needed nothing else to do.
Yes. Anyway, sorry, I distracted you.
199.3, we see what the issue is at page 1001. Do you see that? Against letter H to J.
Yeah.
4 main issues we've got to deal with. 3, does PSED duty mean public authority has a duty only to have regard to the qualities and implications of a decision that it's actually taken? Here, parentheses, the decision to maintain the status quo, not other decisions that might have been taken. And we see then going forward to 239 at page 1009, which 239 sets out the complaints, failed to consider other options which would have been more beneficial, and so forth. And this is the context in which the court says, look, you've got to keep it in bounds, it can't go on ad infinitum, and we see that across the page at 242. Defendant's submission is correct. The exercise of a public authority's functions consists of implementation of the measures the public authority decides upon. Well, quite. In the present case, these were the steps that were taken to change the rule relating to SSP, introduce the job retention scheme. Public authority must have regard to the qualities and implications of the steps it intends to take, including the intentional decision to maintain the status quo. needn't have regard to the quality and implications of other steps. It's not taking, not even considering, else the duty would go on ad infinitum. Public authority would ordinarily have to comply with the PSCD in relation to the decision which it takes in relation to the infinite spectrum of other decisions.
Yeah,
which-
okay,
You've got the point. So it's entirely consistent with us.
well, that's very neat timing.
I think I'm there on ground one.
There on ground. Excellent. We'll move to ground 2 at 2 o'clock. Thank you very much indeed.